Seen this name in a long time. Remember what this name? Abraham Mark.
Yep.
Subscribe to Judge TV. Order.
God,
Yeah.
he's been gone over a year, hasn't he?
So
All right, this is case 25-1647. People of the state of Michigan versus John. Appearances for the record.
Thank you, Your Honor. May it please the court. Assistant Prosecuting Attorney Dan Smith appearing on behalf of the people of the state of Michigan.
thank you, Judge. Tiffany DeBruin on behalf of Mr. Draper, who is currently standing to my left at counsel table.
Looks like he's actually in custody.
He is, Judge.
How long has he been in custody?
Gosh, I want to say it's been about a week, maybe a week and a half.
So all told, he's probably been in custody in excess of 80 days
71 or so,
or 71.
or 70. Yeah.
April 14th was when he came back into custody, Judge. Nope, April 6th. I'm sorry. I was looking at the wrong date on my calendar.
So he has a hearing before the court with regard to amendments on a bond violation. Will this be a plea or request for hearing?
It will be a plea, Judge.
Are you okay with that?
Yes, Your Honor.
So if you'd like to go ahead and proceed, Mr. Broom.
Thank you, Your Honor. With regard to the bond violations, I have a memorandum with, I think, 3 separate violations and separate dates. Does the court want me to just go ahead and establish a factual basis for
So
those?
you're talking about that memo from Ms. Fabry dated January 23rd.
That is correct, Your Honor.
It would take them all sort of seriatim, but so are you okay with that?
Yes.
So do you understand what's going on, sir?
Yes, I do.
So as the person charged with a bond violation, you have a right to have a hearing. At that hearing, it'd be the responsibility of the prosecutor to prove that the violations are true. And if he couldn't do that, then the violations would be dismissed. What I understand from your attorney is that you're going to enter a plea of guilty to those violations. And if I find that those violations are true, you can have your bond revoked and be remanded to the custody of the sheriff for a time period, and you could lose your freedom about that. But it sounds like what she's decided to do is to try and have you enter a plea with regard to the allegations and maybe look at how much time you've already served. What I suspect that she's going to do. Is that okay with you?
Yes, Your Honor.
You can be seated if you like. So, if you'd like to proceed, I guess I should probably swear him in if you're going to be asking them questions. Right?
Yes, Judge.
Raise your right hand. Do you swear or affirm that the information that you're going to provide to the court will be the whole truth?
Yes.
You can lower your hand. I want to make sure that you're doing this voluntarily. Has anyone threatened you or forced you to get you to do this?
No.
Has anyone made any promises to you to get you to do this?
No.
So you're entering this plea because you are in fact guilty of the violations.
Yes.
You've had a chance to go over these violations with Mr. Bruin before you came into the courtroom. Is that right?
That's correct.
Mr. Bruin, go ahead and proceed.
Thank you, Your Honor. Mr. Draper, on November 10th of 2025, were you placed on bond conditions?
Yes.
And did those include do not use alcohol?
Yes.
And were you also required to participate in substance abuse testing or monitoring?
Yes, I was.
And did you test for purposes of alcohol on January 19th of 2026? Did you test positive for alcohol?
Yes, I did.
Is that because you had consumed alcohol?
That's correct.
And on February 9th, did you test at AberHealth?
Yes, I did.
And is it true that you tested positive for alcohol?
Yes,
And is that because you used alcohol?
that is correct.
On February 12th, did you test for alcohol?
Yes, I did.
And is it true that you tested positive?
That's correct.
And is it that because you used alcohol?
I did.
And February 9th and February 12th were those 2026?
That was 2026, correct?
Thank you. And is it accurate that you failed to test on February 16th
Yes,
and February 19th,
that's correct.
February 23rd,
Mhm.
February 24th,
Correct.
March 3rd,
Yep.
March 4th,
Yep.
March 13th,
Correct.
March 17th,
Yep.
March 18th? Okay, and
Yes,
so, no, that's
That's
okay. I know it gets
There's a
old
lot.
saying yep.
Yes,
yeah, the
yes,
same way, but
yes.
just for purposes of the record, we do need you to say yes.
Yes.
Thank you. I think we were at March 18th
18th.
and March 26th,
Yes.
March 27th,
Yep.
and April 1st.
Yes,
And all of those dates were the year 2026. Is that accurate?
that is correct.
And you failed to submit to testing on those dates, even though you knew that you were directed to test on those dates.
That's correct.
You did that intentionally and without fair reason to do so. Yes.
Mhm.
And you are here to take responsibility for that today.
I am.
Thank you, Your Honor. I do believe that that should satisfy the factual basis.
People are satisfied.
All right, I find that the defendant has knowingly, intelligently, and voluntarily tendered a sufficient factual basis to find him guilty of the bond violations as indicated on the record before the court. So have you guys had a chance to chat about what might happen as a consequence of this hearing today?
We have not, but I defer to the court.
Judge, I assumed that part of this would be that his bond would be revoked. He has been in since April 6th. It's my intention, I believe Mr. Smith is here covering for Ms. Izell. I have reached out to her to see where we might be for a potential resolution in the case as a whole. I have not been able to actually touch base with her, so that's going to be my next step. I know usually in a bond violation, the court will revoke bond, and I don't know, what other measures the court will take in order to ensure compliance moving forward. I do know I am not the first attorney on this case. I was hired in, and I apologize. I was not aware of the warrant. I think that's something that Mr. Draper and I did not address specifically. So I do apologize. But once Ms. Faber reached out to me and told me there was a warrant, it was something that I worked with Mr. Draper to discuss, and he came in voluntarily. It was not something where he had to be brought in the back door. We came in to do a walk-in arraignment on April 6th. So he's here, he's ready to proceed. We are ready to move forward with the case. And so I understand if the court determines he needs to remain in custody pending the rest of the court case. And certainly we're open to whatever else the court thinks is appropriate.
If it would be appropriate to have him have a substance use assessment done while he's in jail.
Yes, Judge, we understand.
Okay. So probably what we should do is schedule this for an assessment. How quick do you think we could get one?
Cats. They're usually pretty quick. I would say within 3 weeks. They respond right away to my
Yeah,
paperwork.
maybe if we can get them to expedite it, that would help. Because 3 weeks, I mean, with them already having been in jail for a couple of weeks already.
We appreciate that, Judge.
Is this matter still scheduled for jury selection?
No, Judge, I think when the warrant went active, it was something where they canceled the jury selection.
Okay.
So I'd be requesting a pretrial.
But let's give them a date for a pretrial and let's see if we can get a substance use assessment in that time frame.
You could set that for either April 28th in the afternoon or
Let's see.
go to May 4th. It could be morning or afternoon.
You said April 28th in the afternoon.
Yes.
I serve on jury court and Veterans Treatment Court up in Clinton County, and that is a Tuesday when we have our treatment.
Okay, how about May 4th, morning or afternoon?
May 4th, I've got two other things scheduled one thing at 8:30 in Eaton, one thing at 9 in will via Zoom. I don't know, that one shouldn't last more than an hour. Would 10:30 be an option?
Sure.
Or in the afternoon.
In the afternoon, I can do probably anything between 1:30 and 3:30.
1:30 p.m.
Is
Perfect.
that for the
May
pretrial?
4th, yes.
So the pretrial is May 4th? And we'll just say 1:30,
Yes.
and we'll try to get him an assessment too before then. Okay.
And I will have talked with Mrs. L and see if we can figure out exactly where we're going with this. I will keep my client apprised of what's going on.
I don't know if I actually said it, but I find that there's a sufficient basis to find the bond violation exists, that he's guilty of the violations. And pursuant to that finding, we will arrange for him to have a pretrial while he's in custody, and as well as a new assessment to be completed for him. Okay,
Yes, Judge.
we've covered everything.
Yes, nothing further from the people.
Rowan, anything else further for you?
No, Your Honor.
And Mr. Draper, sir, any questions or concerns?
No, sir.
Then that's going to be off of the record.
Thank you, Your Honor.
Thank you, Judge.
Okay, appreciate it.